Hi everyone, Tim Berry on behalf of GartlandLaw.com. One of the most often asked questions we get is, what do I do with the corporation that I haven't used in a couple years? It's racking up, it's mounting up all sorts of franchise tax fees. I haven't used the thing, but I don't want to have to pay that $800 a year minimum franchise tax fee. And that brings up the interesting question, whose debt is that franchise tax fee? Well, at its most simplistic, that is a debt that the corporation owes. That is a tax the corporation owes to the Franchise Tax Board. It isn't a tax that is owed by the shareholders. Now, some people say that the Franchise Tax Board can come through, pierce the corporate veil, and go after those assets. But there's a case, I was going to say famous, but maybe it's infamous case, and it's typically known as the Ralite case, R-A-L-I-T-E case. And this Ralite case, the situation was, well, just like the questions that are always being asked about who is responsible for the franchise tax fee. And in this case, it was accepted that it was the corporation, not the taxpayers, or I'm sorry, not the shareholders, but it was the corporation that owed the tax liability. Now, the interesting thing is the Franchise Tax Board went after the shareholders of the Ralite Corporation in this case. And the reason they went after him was it was under the theory of a fraudulent conveyance, a fraudulent transfer. What had happened is that the shareholders had taken a large amount of money out of the corporation, well over $70,000, and they just kept it, even though the corporation went down the tubes. And so the Franchise Tax Board came and said, hey, look, we understand the franchise tax fee is a liability of the corporation. However, you shareholders took the money out of that corporation, a large amount of money, and therefore that was a fraudulent conveyance, and therefore you owe the franchise tax fee. Now, at the end of this case, where the bottom line was the shareholders were liable for the franchise tax fee. But the interesting thing is, reading between the lines on this case, the shareholders probably would not have been liable if they had not transferred a large amount of money out of that corporation for their benefit. So, let's get back to the basic question. If you have a corporation that you haven't used, if you have an LLC that you haven't used for a large amount of years, for a number of years, and it's racked up a large amount in franchise tax fees, is that your liability or is it the corporation's liability? It's the corporation's liability. Can the Franchise Tax Board come after you personally for that? Well, that's an open question, but more than likely, based upon this Ralite case, unless you've made some sort of fraudulent conveyance, I think it's going to be a challenge for the Franchise Tax Board to come after you. Once again, this is Tim Berry on behalf of GartlandLaw.com. If you have any questions, please visit us on the web, www.gartlandlaw.com. Thank you.